Welcome back to Face Off, where Judy and I are debating the issue of jury selection with Doug Hunt, a former Crown Counsel, and Karen McArthur, a criminal defense lawyer. Karen, I just want to get an idea of where exactly you are in this scale of things here. You don't want to go the O.J. Simpson thing or the American thing. Like, that took 3 months or something for jury selection.
It's a bit lengthy.
Yeah, we had the Bernardo thing here that took 2.5 days. Right. Now, I understand you want to go somewhere in between. What sorts of questions?
Wouldn't that be a Canadian thing to do?
Well, I think it would be. What sort of questions do you want to ask?
I think we should be able to ask questions about people's associations, about and get answers that are more than the yes or no answers that we currently get.
But isn't the purpose to load up the jury?
Generally speaking, we ask the judge, first of all, for permission, and judges, in my experience, have been crafting the questions so that all we get from the juror, the prospective juror, is yes or no. I think we'd be able to glean much more information about a prospective juror and how well they would be able to fit on the jury and whether or not they would be able to fairly try the case if they could expand a little bit more on their opinions about guns and drugs, sensitive areas, politicized issues.
But isn't the idea to get a jury more favorable to you?
To our modern political parties and have our, topic number one in the provincial election right now. Really, one of the top issues is crime.
Yes.
And so it's a relevant issue that I think we should be asking of these prospective jurors.
But do you agree with that, Doug? I mean, no. What is your view on crime? Have anything to do with your decision as a juror?
I think once you start down the road of opening up questioning of prospective jurors to leaving it to the discretion of the counsel asking the question, that we will soon be at the place where you can ask 294 questions of the juror because there's no way to control it. And
but Doug, I'm not saying leave it wholly in the discretion of the lawyers. I'm saying still vet it through the judge. But let's have a little more leeway than what we have now. And let's also move away from this approach of, we got to get this jury picked and do this jury trial as quickly as possible.
Well, I don't think there is that pressure to get it picked without due regard for the impartiality of the jury. But once you start into the area of what the witness or the prospective juror believes about something, who they like to associate with, what the credo of the association is,
who they like to
you start down a road that there's no way to come back from, even with judicial control.
But you said earlier, you said yourself, if there's a body of social science that shows there's a prejudice, well, I mean, there's a lot of bodies of social science that shows there's all kinds of prejudice, right? So even you're opening it up to a lot more questions.
With judicial control, you can get the information you need, I would suggest, in 6 or 7 or 8 questions. We don't need to have a sort of an indiscriminate fishing expedition to get to the bottom line on the question. We depend on juries to come in, citizens come in, they don't get paid. We ask them to do a very important job of listening to evidence and judging one of their fellow citizens. If we start down an exercise where we turn them into the person who's on trial, the system's going to lose credibility. We're going to lose juries as an effective way of determining guilt or innocence.
I actually don't think that Doug and I are that far off in our views, even though you've introduced us as being diverging views. He's saying just don't open it up wide, the 294 questions in the O.J. Simpson case, and that's what I'm saying as well. But I'm saying we have to be put in a position that we can ask questions about associations, about political views, in a way other than yes or no.
That is
in a way other than yes or no.
How do you do that without
go through the judge, and I disagree with Doug that we have to put forward this body.
Let me raise something with you. Okay, I was involved in the Morgenthaler trial, and I'm very glad of the outcome.
Right.
But Morris Manning asked the women, "Are you Miss, Ms., or Mrs.?" And the ones who were Ms. he considered to be not just. It wasn't just a question of fair; it was favorable. Now we know defense lawyers. And we know that if defense lawyers have a chance to ask questions, they're going to try and get the jury most favorable to their clients.
And defense lawyers are like, when the prospective juror goes up there, they're going to look to see whether or not there's a wedding ring on, how they're dressed. And based on the defense or Crown Counsel's own personal views, will peremptory charge people.
So you can see that it's trying to load up the juror.
No, not that you're trying to load up the jury. You want a jury on there that your defendant feels comfortable with, that you feel comfortable with, and that will appreciate and understand appreciate and understand the case and be
Well,
able to
okay,
decide it
here, I'm going to put to
fairly
both of
on
you. Let me
evidence.
put to you this expert in jury selection who says, for the Bernardo trial, he'd seek out angry, unemployed white males in their late 20s and early 30s with a visceral opposition to matters such as gun control, if he were the defendant. Now, I mean, where does this get us? This kind of, imaginary creation of who's the perfect person to be on the jury.
It's all hocus pocus and intuition, and that's in large part what people have to rely on now. The thing that I think is
Foreign questions better then?
Well, but I think the danger that's going to bring is we're going to turn the prospective juror into the one who's on trial. We're going to put in jeopardy their cooperation in the system. Well, the limit, but I think the limits I'm talking about and the ones that you're hoping for are quite different. I'm saying you can get all the information you need
You're not going
in
as
5
far
or 6
as Claire
questions.
and saying throw the first 12 up. You're not saying that either.
Well, I wouldn't put the first 12 up in every case, but I think
exactly.
You
Most people don't go as far as I do, Karen. It's okay. This is not unusual.
Your opinion.
I'd like to thank our guests tonight, Karen McArthur and Doug Hunt.